Mover Nation, the day was upon us. Was it a good day for Alex Murdaugh in court or not? We're going to find out. We're going to talk about it. We're going to go over the hearing today with Judge Toal, go on some excerpts. This is, I did a live earlier while it was going on. This is my independent cogent analysis. After the fact, we're going to get into it. I'm Collier Landry. Hey, let's get into it.
Testimony continued today in the most notorious criminal trial in...
When I was 12 years old, my testimony sent my father to prison for murdering my mother. I decided at an early age that our trauma should not be what defines us. It's what we choose to do with it that does. I'm here to share my unique perspective on true crime, mental health, society, and popular culture, albeit with a slight sense of humor. I'm Collier Landry, and welcome to my show.
Mover Nation, what's going on? How's everyone today? Thank you so much for showing up for the second live of the day. I have taken this Murdaugh hearing that went on, this status hearing. Sorry, I'm fixing my hair. I ran home from the gym, quickly did a quick little, they called it a Navy shower, even though I never served in the Navy, but I'm told it's a naval shower when you do it in like under 2 minutes. And here I am. I was exporting this this footage from earlier to try to get us some better audio levels since they were really low during the actual hearing. But I think we might not have that going on. So yeah, let's see here. But as you guys know, I've been following this whole this whole case for this whole Becky Hill debacle with the book Behind the Doors of Justice. I've done a bunch of videos about it. Everybody seems to be weighing in on this today, and I'm a pundit, I've realized. So I'm here to offer my my cogent analysis on what I think based on my own experience. And yeah, so good evening, Lynn Clow. Good evening, Tina Luffman. Hello, Rhiannon Rose. How is everyone doing? Where is everybody else at? I guess they're on more interesting lives. I don't blame them. Everybody's been talking about this all day. So, and my dog downstairs is going crazy. Oh, Marisol. So, earlier today, there was this status hearing in the Murdaugh case, and we are going to... The girls are in the house. Yes, they are. Yeah, I guess this is not going to work for me, which is fabulous. Okay. So I'm going to play... We're going to get into some certain parts because I had it running. I was sort of offering some spot on, just kind of as it was going, analysis, but I definitely have some more analysis going on that I want to offer because I've had a chance to watch it over and think about it, and it is yeah, it is a thing. I'm trying to quiet my Alexa, and I'm going to have to go quiet my dog. It's always something, movers. And wherever you may be and however you may be listening, thank you for making me a part of your day. There are some new channel members that have just joined. I want to give some recognition to. Our latest channel member that just joined is Super Planner Girl. Welcome, Super Planner Girl, wherever you are. Hi, Shago Guitarist. Thank you so much, Tina Luffman, for the super sticker. I greatly appreciate it. Yes, Super Planner Girl joined today, I believe. So thank you so much to Super Planner Girl for joining, and thank you to Tina Luffman for your super sticker. So, going to get into some of this analysis really quick as soon as this file uploads. So, Alex Murdaugh was back in court today. This is the status hearing to determine what evidence is going to be allowed and what witnesses are going to be able to be called, and what the judge, who is Chief Justice of the South Carolina Supreme Court, or former Chief Justice, I should say, of the South Carolina Supreme Court, Justice Jean H. Toal. Come on, man. What is happening here? All the music has just decided to play. I turned this on for my dog during the day. Anyways, I might have to go downstairs and there we go. Great. Finally comes up. Alexa's not that fast on the phone. But, so first actual live you have caught. Been loving your content. Thank you for telling your story with a slight sense of humor. It makes me want to do the same. Well, I'm happy to be an inspiration. Norraine Wheels, thank you so much for joining and finally catching a live. That's great. Welcome. So there's been a okay, so back to this hearing. You know, I tell people that I'm going to be live, and I say, hey, I'm going to be live. Oh boy, here we go. Wi-Fi. Technical difficulties. Hang on, guys. There we go. Volume now, right? It muted. Listen to the hearing today while driving through Walterboro. Strange. So strange. Yeah, I'm sure it is. I should be back with the audio right now. Let me know if that works. If that is working for you guys. So all right. So today was an interesting day because I'll tell you, I have been very much on this whole Becky Hill thing, and I was thinking for sure that this was most possibly probably going to be a slam dunk for him to at least have a good hearing, let alone get a retrial. Now, I am I am absolutely no fan of Alex Murdaugh whatsoever. I do think that, in my own personal opinion, again, I am not a lawyer. I am not law enforcement. I am not a psychologist. I'm just a guy who's been through a lot of shit. In my opinion, there's something that's rotten in Denmark. I always thought just the corruption was on the Murdaugh side of things, but now after seeing and learning and watching, checking out this wonderful book, which I've talked a lot about, I should get some commission for that, for sales. If you can buy it, that is. Still, which you're not supposed to be able to. I do think that something is a little wrong, but I'm going to get into that at the end of this live and give you guys my opinion. We're going to check in and see what you guys think as well. So, let us pull this up. I'm going to go through selected parts here. And I'm pretty sure that the first part of this, let's see. Okay, great. I like this right now. So, this is not going to have any audio for a while. This is all background, blah, blah, blah. And they uncuff Alex Murdaugh. And now we finally have audio. I truly believe... So the book is called Behind the Doors of Justice, Jan. And it was written by Becky Hill, who is the Colleton County Clerk of Court, who was the Clerk of Court during the Murdaugh trial. Now, I and a lot of people think
this is a pre-hearing procedure in the matter of state against Richard Alexander Murdaugh.
So this is a status hearing to essentially decide like what witnesses are going to be allowed, what the state is going to present, what the defense is going to present for this larger hearing about a potential retrial for Alex Murdaugh for his murder convictions. Now, he is currently serving two life sentences. I think they're serving concurrently. He's also serving like 27 years for the financial crimes, which he pleaded guilty to, and federal cases. He's got a lot. The guy's going to, whether or not you like Alex Murdaugh, and I know that a lot of people He was convicted for the murder of his wife and son, his wife Maggie, his son Paul, youngest son Paul. His older son is caught in the middle of this buster. I've talked about him extensively. I feel like I have a very kindred spirit with him in a lot of ways because I know exactly what he's going through. It's a lot of confusion and just a lot of it's a mess, and I wouldn't wish it upon anybody. But this hearing today was to establish like what witnesses, who's going to call what, and what the judge is going to allow and not allow in the hearing, which is coming up on January the 29th. So it's scheduled right now on the calendar for January 29th, 30th, and 31st. I will also be covering that as well and live. I'm in Los Angeles, so I'll be getting up very early. I think it starts at like 8:30, so I'll be at 5:30 ready to rock here on Pacific time. Something like that. Maybe it's 9:30 when they open up. But we'll be discussing all that. Done some thinking since your last live for this. While A, I dislike him, B, I think he's guilty, and C, I think a retrial is a waste of time. Agree it should happen if shady shenanigans occurred. I would agree with that, Shago Guitarist, because this is the justice system in the United States. It works for the worst of us, so it can work for the best of us. And if things like this can happen, then, it can happen to us. You know what I mean? So I have a lot of thoughts on all of this over the weeks. I've talked about it. The judge did smack Dick Harpootlian around a little bit, and she was not suffering fools. So I don't know about anything where people would be paid off or any sort of shenanigans like that. I can't speak to anything. I am not familiar with South Carolina politics or how any of this works. But what we will get into is what went down in the courtroom today and what she's going to allow. And that's what I think is the most interesting because, I think a lot of people felt that, like myself, that this judge, Murdaugh's side of the defense is arguing that he that because Becky Hill wrote this book, had improper contact with the jurors, that they feel, and that somehow swayed the jury by her skills of persuasion, speaking to the forum in the bathroom, the jury foreman in the bathroom, etc. That these things somehow tainted the jurors' verdict in their minds. And there was one specific juror who was removed, the egg juror. There's a lot of speculation around this Facebook post that they believe that Becky Hill had promoted in an effort to get this person dismissed from the jury a day before the verdict was handed down. So there's a lot of gray area, and Justice Toal is here to sort of weigh in and say, this is what I think I'm going to allow and what I'm not going to allow. The biggest blow I saw for the defense, and again, not a lawyer, not a legal expert, not a psychologist, not a law enforcement, just a guy who's been through a lot of shit. Where I thought she would allow certain things, or would say, well, because the defense is saying, hey, look, it doesn't matter if the jurors, and they cited a bunch of case law, that the jurors were going to change their mind or not, that somehow their decision was persuaded by Becky Hill's behavior. They're saying that doesn't even matter because in prior case law, this has been allowed. So the judge addresses all of this directly, which is very interesting because there is this, it makes the defense's case much harder because she wants to show that she wants them to prove that there was prejudice, which means that they want the jurors to get up there and say, I was going to vote not guilty until Becky Hill said X, until I heard X, until I was persuaded by her and her comments to change my verdict to guilty. And that's the crux of the case for the defense. I'm going to pull up the defense motion that they filed so I can kind of read it along with you guys. And I read this the other day. And this is the second supplemental pre-hearing brief. So the defense had claimed, they need to, they're going to go through this. All the potential witnesses during the evidentiary hearing, which was coming up, they cited a bunch of case law. They are looking with important caveat. At present, Mr. Murdaugh plans to call the following witnesses in his case in chief during the evidentiary hearing: Juror 254, 630, Juror 630, Juror 741, Juror 785, and Rhonda McLevin, who's the Barnwell County Clerk of Court, who is very close with Becky Hill, supposedly best friends. Additionally, they want to call Aubrey M. Hill, which is Miss Hill's daughter, Creighton Waters, who is the prosecutor for the trial, Carly Jewell, another assistant AG, David Owen from SLED, and Rachel Joseph from SLED. And the state, they are saying, must call Miss Hill to deny the allegations that she tampered with the jury. Depending on Miss Hill's testimony, Mr. Murdaugh might call some of the following witnesses as rebuttal witnesses: Laura Hayes, former deputy clerk of court in Colleton County; Jeffrey Hill, who is her son, who is currently being charged with 1 count of wiretapping; and Clifton Newman, who is a retired circuit court judge who was the one who presided over Murdaugh's murder trial. Tim Stone, ex-husband of the juror 785, and Timothy Stone, original poster of the Facebook message presented to Judge Newman during the trial and included in the court's exhibit number 4, which has to do with this egg juror that was removed, who I believe is juror 630. So they're going to get into this, and they're also going to get into because in this hearing present are attorneys representing pro bono, representing some of these jurors. I believe 4 of them. There is Eric Bland and his partner Richter. So it's Richter and Bland, the law firm, and they have shown up requesting things like not having. Well, we're getting into that. We'll get into it. Let us go into, and I'm going to just kind of fast forward through this, guys. I'm also going to put myself in the bottom corner. There we go. Great.
It's case numbers 2022-GS15-00592 through 00595. Defendant Murdaugh was indicted for the murder of his wife, Margaret Branstetter Murdaugh, and his son, Paul Bennett Murdaugh, and related weapons charges. His trial began on January the 23rd, 2023. The presiding judge was Clifton Newman. After 6 weeks of trial,
just giving a little backstory. So this is Justice Jean Puffer Toal.
The jury returned a verdict of guilty on all 4 indictments, on which the defendant was sentenced on March 2023 to 2 consecutive terms of life imprisonment. Notice of appeal.
I was wrong. They are consecutive terms,
were filed
not
by
concurrent.
Defendant Murdaugh's attorneys on March the 9th, 2023, with the South Carolina Court of Appeals. The transcript in this very lengthy trial took several months to produce, even in draft form. Before the attorneys received the final transcript, on September the 5th, 2023, defendant filed with the Court of Appeals a motion to suspend his appeal and
10 degrees in Ohio.
File a motion for
That's
a
terrible.
new trial with accompanying
Worth saying if he does.
transcript experts.
Worth saying that if he does get a retrial, I'm inclined to believe that the result will be the same outcome. Yes. I think that I think that might be the case. I don't want to make you guys sad. It's 63 in St. Petersburg, Florida, but don't be mad at me, says Rhiannon Rose. Well, it's 60. No, it's what is the temperature here in Los Angeles? It is 61 degrees right now in Santa Monica. So you have us beat. Okay. So
After further defense of this portion of the proceedings, but if any device rings or sounds to receive a call, or I would.
Okay. You raised a number of legal issues from,
Now, she's going to bring up.
If you have not already, during the first break, be certain that all of you, the lawyers participating at council table, and any other lawyers that feel they may have some interest in the proceedings that would warrant comment by them, please give your cards or information about your contacts to our court reporter, Ms. Harris.
All right, so let's get into Dick Harpootlian. This is Alex Murdaugh's attorney, as we all know.
I would.
okay. You raised a number of legal issues from whether we waived, I mean, a number, I forget the order in which you just took them, but Mr. Griffin is going to address those.
Rhiannon Rose, that's funny.
Based on what you said just a moment ago. As to the witnesses and the jurors, I will be handling that portion of the argument today.
Very good. Mr. Griffin,
That is not
we're
me,
here
by the way.
now.
Yes, thank you, Your Honor. The first issue that you've asked us to address is an evidentiary hearing necessary? And the answer to that question is very straightforward, is yes, under established case law in the Supreme Court, the Fourth Circuit, and the South Carolina Supreme Court under Reamer. A Reamer hearing is absolutely necessary where there has been credible evidence presented that there's been improper third-party contact with the jury prior to their deliberations that frankly, whether it goes to the merits or not, a Reamer hearing is absolutely necessary. And we believe that the Court of Appeals decision in this case contemplated a Reamer hearing. And in a Reamer hearing, evidence is presented as to what outside influences, if any, were brought to bear upon the jury. We have, in our motion for a new trial, submitted affidavits of one deliberating juror, one alternate, and then another.
So what he's talking about is the Reamer hearing, and this is in section C on page 15 of their supplemental of their pre-hearing brief that they submitted on the 12th, on Friday, right? 12th, yeah, 12th on Friday. Discussing South Carolina case law provides the controlling legal standard. As discussed above, the burden shifting described in Reamer is not relevant to this case because the alleged communications were by a court official to at least one deliberating juror and inarguably pertained to the merits of the case being tried. This is because South Carolina case law versus Cameron provides the legal standard, not Reamer. If Mr. Murdaugh proves that the clerk of court engaged in surreptitious advocacy on the merits during trial, there is nothing for the state to rebut. A new trial is required. So that's what they are saying in section C of the fourth part of this document. To clarify your argument as to whether the defendant is entitled to a new trial, they're referring to this Reamer hearing, and she weighs in on this.
Affidavit of a witness to an interview of an alternate.
Yeah, she was very no nonsense.
All three statements are consistent, and in that they heard Ms. Hill, the clerk of court, prior to deliberations, and frankly before the defense put on their case. Ms. Hill instructed, do not be fooled by the defense. That's what the sworn statements say. And secondly, before Mr. Murdaugh took the stand, Ms. Hill advised one deliberating juror and two alternates, at least, watch his demeanor.
Is that how we spell malarkey? No, Lynn Clow. Any thoughts on Alex fidgeting and movements during this hearing? Oh yeah, for sure. First of all, yeah, he's got to be extremely nervous. He's very fidgety, and you know, this is the man's life on the line, right? I would probably be fidgeting too. I fidget right now during these lives, like fidget and move things. I'm like, oh, scratch this, that, and the other. I mean, we're watching his body language. I always find it funny when people talk about watching other people's body language, especially in courtroom situations, because they, you know, oftentimes sometimes it's like, oh, we're putting this person under a microscope. So, are we really, if we looked at everybody the same way, I'm sure we all do things we all have tells and we all have this. But yeah, he's moving, he's rubbing his head a lot. He's, I think as the hearing progresses and as we start to learn that, because we see, one of the things as we see as we go through this is we start to, like, this is really teeing up whether or not he's probably going to get a retrial. And it does not look it does not look good for Alex Murdaugh at the end of this. I don't think, but that's just my opinion. Whether they're actually going to go through, because this is the same judge that's going to sit and listen to the court's arguments, or to the arguments before the court. So it is, I don't know. A lot of people are saying withdrawals. I don't know if he's on any substances or not.
Those contacts happen, and then we proceed from there as to what the burden of proof is after that. But the threshold: are we entitled to evidentiary hearing? The law is crystal clear that we are.
Thank you, sir. Mr. Waters?
Now, Creighton Waters comes in.
Thank you, Your Honor. May it please the court. Your Honor, obviously, you've addressed the issue of whether an evidentiary hearing is necessary. The state certainly understands that. It is incumbent upon us, though, based on
No
the
death
law,
penalty,
to preserve our arguments as to procedural bar, and those are twofold. And the first one, of course, is that a motion for a new trial must be filed within 10 days of the verdict unless there's after discovered evidence. And I think an initial inquiry that needs to be determined is when the defense first learned of these particular allegations. In conversations with the defense, and they said they're going to give me an answer, that they may have had conversations with juror 785 prior to her being represented, which was only a couple days after trial. So if that is the case and they were aware of these allegations, then we would want to argue to Your Honor and preserve the issue that this is not after discovered evidence and that there's a procedural bar in that regard. Secondly, we made the argument that the affidavits on their face, the only deliberating juror indicated, and that's 630, in that affidavit only said that she
I would agree.
Voted guilty. She had questions but voted guilty because she felt pressured by other jurors. And of course the law is crystal clear in multiple cases that sort of internal debate, it's actually in Rule 606B, that's not any sort of misconduct or anything that is a appropriate venue or mechanism in order to attack the verdict. So for that reason, we've argued that their showing in their motion for a new trial is insufficient based on the case law for an evidentiary hearing because there is on its face no sufficient allegation of prejudice. That being said, of course, we fully understand and expect the evidentiary hearing will go forward, and we'll be happy to address burden of proof after the defense makes their arguments.
So what they're arguing, so the whole crux of their argument and of what Justice Toal is going to start talking about in a minute is that you have to show prejudice, that the jury, that because of what Miss Hill did or what her actions were, because they're all here because of her, essentially, because there's the jury tampering. Then they've used this book that she wrote. I'm going to keep bringing this book up with all my little tabs. That because she did this, she like that's why they're all here, right? And that she tampered with the jury, she abused her power, and that's why they're even sitting in this courtroom. And the defense is saying it doesn't matter if the juror was influenced or not. It's the fact that she did it in the first place that there was a miscarriage of justice, and that Alex Murdaugh did not get a fair trial. It doesn't matter if the juror actually says that outcome affected their verdict, right? When they weighed in for the verdict. And so that's what prejudice is, right? There was no prejudice. And that's what the state is arguing, that did not affect any of that. Her actions did not affect that. And therefore that it's a moot point and for a retrial, but they're still going to go through the motions, as he says. They're happy to do it and then happy to offer the burden of proof. But remember that it's a key point, because this judge seems very caught up in prejudice and did this affect the verdicts, which to me is it's a lot. It's, and I'm not here to again, I'm not an Alex Murdaugh fan in the slightest, but I am a fan of everyone getting an equal opportunity for justice. Thank you so much, Cat Loves Catskills. Well, we shall find out if that happens.
Very good. All right. With respect to, Mr. Griffin, anything in reply?
Your Honor, it does not appear that the state, takes a position contrary that a Reamer hearing is required. They're arguing that we have sort of waived the right to that hearing. There's no evidence of the record of that. I can assure the court we did not know of this information within 10 days after the trial. And when we learned of it, we promptly acted. That's all I can say.
Well, in conversations with Mr. Harpootli and Mr. Griffin, they were going to actually look into that and look at their paralegal's notes. So I fully rely on and trust the defense to give me a fair answer to that question. And then again, if there's an issue to be raised, we would raise that. We're not conceding anything. We just wanted to preserve our procedural issues.
I do feel like it is kind of, while this can easily turn into a circus for sure, I do like how the lawyers, they all do seem to have complete respect for one another, which is great. You want to have a formidable opponent in court. And I do think that there does seem to be, they do seem to have, at least in front of the cameras here, they seem to have a modicum of respect for one another and a sense of decorum, which, in today's day and age is a stretch for a lot of people. So I do appreciate that a lot. Now we'll hear what Justice Toal says.
We need to go back and forth many times about this. I think I understand your position. Here's my position.
And there's lawyer Lori.
First of all, I am not conducting a Rimmer hearing.
Sitting next to Mr. McCullough.
A 1954 decision.
The gentleman in the white hair, if we go back, who is sitting next to lawyer. Oh, geez. Did I just screw all this up? I hope not. Lawyer Lori. All right. Jeez. So that gentleman there is Mr. McCullough, who represents other jurors that are a little more Murdaugh friendly. Yeah, I think I completely messed this up. Sorry, guys.
And things like that. And then there's external allegations of external influence and that sort of thing. And that's what we're dealing with here today. And to quote State v. Green,
in the State v. Green, the Court of Appeals says that affected the verdict.
Specifically on what must be proved in a hearing of this nature and who bears the burden of that proof. All right.
there is on its face no sufficient allegation.
Okay, here we go. Sorry, guys.
That said, of course, we fully understand and expect the evidentiary hearing will go forward, and we'll be happy to address burden of proof.
Backing it up to the evidentiary hearing that will go forward.
Very good. All right. With respect to, Mr. Griffin, anything in reply?
Your Honor, it does not appear that the state, takes a position contrary that a Reamer hearing is required. They're arguing that we have sort of waived the right to that hearing. There's no evidence of the record of that. I can assure the court we did not know of this information within 10 days after the trial. And when we learned of it, we promptly acted. That's all I can say.
Well, in conversations with Mr. Harpootli and Mr. Griffin, they were going to actually look into that and look at their paralegal's notes. So I fully rely on and trust the defense to give me a fair answer to that question. And then again, if there's an issue to be raised, we would raise that. We're not conceding anything. We just wanted to preserve our procedural issues.
I don't think we need to go back and forth many times about this. I think I understand.
And there's where she's no nonsense.
Here's my position on the matter. First of all, I am not conducting a Rimmer hearing. Rimmer is a 1954 decision of the United States Supreme Court that deals with the question of influence of the jury and a motion for a new trial on the basis of after discovered evidence of that influence. I rely on the South Carolina decision of our Supreme Court authored by Justice Kittredge, State versus Green. And the Green decision specifically says that Rimmer is not the guidance that South Carolina trial judges should look to in conducting hearings on after-discovered evidence. Now, that says nothing about what the burden of proof should be, and I don't intend to say anything thereby. But I do intend to tell you right away that I will be relying on South Carolina's jurisprudence and South Carolina's jurisprudence specifically on what must be proved in a hearing of this nature and who bears the burden of that proof.
And who bears burden of that proof?
And that leads to the very next topic that we'll now take up, which is the burden of proof. Mr. Griffin?
Yes, Your Honor. As we cited in our papers,
So throwing out Remmer,
that
referring to Green.
controlling case in this instance based on the scope of conduct as alleged, and that is conduct of a court official, here at Clerk of Court, having communication with the jury,
Becky
about
Hill.
the substance or the merits of the case, that the standard to be applied is not Green, because Green, Judge Kitzer says that the contact by the bailiff was about a procedural issue, not about the merits of the case. Here we're dealing specifically with the merits of the case, and the Court of Appeals decision in State v. Cameron, we believe, is the controlling standard.
Prison doesn't look like it's been unkind to Alex Murdaugh.
That was decided in 1993.
I mean, he looks terrible in my opinion, but prison sucks.
The United States, which is a Fourth Circuit opinion, says in this case there was a private communication of the court official to members of the jury, an occurrence which cannot be tolerated if the sanctity of the jury system is to be maintained. When there has been such a communication, a new trial must be granted unless it clearly appears that the subject matter of the communication was harmless and could not have affected the verdict. Now, we strongly believe that is the standard. Is the question of, was the subject matter of the communication harmless and that it could not have affected the verdict? And we are, that's our position on the standard. Your Honor, if Your Honor looks to a different standard, we believe that State v. Green, the measure of State v. Green, you can't look just at Justice Kittredge's opinion. You have to look, because he complimented the Court of Appeals decision. And the Court of Appeals decision absolutely applied the Reamer standard of the burden of production is on the defendant, but when the defendant produces evidence of a substantive communication to the jury by any third party, that's what Reamer is, by any third party, that then there's a presumption of bias. And that the state then has to overcome that presumption, produce strong, clear, and convincing evidence that it was harmless.
Now, the crux of the Green case right here, the Fourth Circuit explains, with respect to the presumption of prejudice, we have recently observed that there is a split among the circuits regarding whether the Reamer presumption has survived intact following the Supreme Court's decision in Smith versus Phillips. And therefore, it controls our approach to the Sixth Amendment issue, which Green raises. So the Sixth Amendment is the right to a fair and speedy trial. No, hold on. No, sorry. That's the Fourth Amendment. I took government. But that's what they're referring to, is this Green case going back and forth between the Remmer or Reamer decision. Reamer. He says it Reamer. They say Remmer. Tomato. The scope and currency of... No, hold on. So this is what was raised in Section C of their pre-hearing brief that the defense prepared.
And that was the standard that the Court of Appeals applied to State v. Green. And in State v. Green, the Court of Appeals says that this is the standard of the Fourth Circuit, and we follow the Fourth Circuit law in this area. Now, Justice Kicker says that the communication by the bailiff, which essentially said, if you're deadlocked, which they never were and never became deadlocked, then the judge may ask you to stay longer. I mean,
I was right, by the way. It is the Sixth Amendment that that gives you the right to a fair and speedy trial. I knew I wasn't going to mess that one up.
that was the communication by the bailiff in Green, and Justice Kitcher said that did not go to the merits of the case. Justice Kitcher didn't throw out the Reamer presumption standard in State v. Green, Your Honor.
Who knows? He could be on all kinds of. He could be on psychiatric drugs. I mean, being in prison is awful, horrible, and he was a drug addict for a very long time. And yes, you can make. Not that I have any experience in this, but you can make drugs. There are drugs in prisons for sure. How they get in there is beyond me, because everyone that goes into a prison gets searched thoroughly. So, bringing drugs into a prison is not an easy feat, but they manage to get them in somehow. Who knows how that occurs?
The Court of Appeals decision looking to the Fourth Circuit because, as Your Honor knows, this case, and I would encourage the court to look at the Holmes decision out of the Fourth Circuit, which we cite, which applies Reamer. It applied Reamer in a habeas corpus case when they said Reamer is the clearly established law in the Fourth Circuit. And it vacated a death penalty conviction out of North Carolina because the North Carolina courts did not follow Reamer. And so the Court of Appeals decision in Green says we look to Reamer. Justice Kitcher says...
I would agree with that. Absolutely. Absolutely. So one thing you have to understand, too, is that he's a lawyer, right? So my father's in prison for murdering my mother, as you guys know, because you watch the show, right? So one of the things is that my father, who is incarcerated, found I don't know if it's easy, found a way to make a life by offering, somebody medical advice, other inmates, prison guards, etc. Somebody with an education in a prison, like a lawyer. I'm sure he has a lot of enemies, but I'm sure he also has made a lot of friends because he can use that as currency, because he could read through people who are trying to appeal their convictions, let's say, and go through and offer his services in trade for food, drugs, money, what have you, favors in the cafeteria, better, cleaner linens, a television. He can barter his services in prison. He's a valuable inmate to not only the administration in the prison, but to also the other inmates, because many inmates that are incarcerated are all fighting cases or have active cases open or are facing more cases that they are being charged with on top of the crime that they're already incarcerated for. So he's a very valuable asset. So while he might be, while prison is horrible, I'm sure he has found a way to make it work for him in a way that he can survive. And that was just in my own experience in dealing with my father. That's what I found out, that you use the tools that you can, just like in any situation, for your own personal survival and betterment while you're incarcerated. It still sucks. You're incarcerated.
Didn't go to the merits. What we have in this case, and what we have, presented through proffer on the affidavits, something that goes to the heart of the merits. It's the defense. And it's the credibility of the defendant's testimony. And so we do have the burden of production, but we do believe that the standard in Cameron is we just have to show that the subject matter of the communication, that it was material to the case, and that then the burden shifts to the defendant to prove that it was harmless. The burden shifts to the state to prove it was harmless. That's what we believe the standard is.
And that's what they believe. So essentially what he's saying is that all they have to do is prove that she communicated with the jurors or the foreman or whoever, and that's all they need. Not that she actually influenced any decisions, and that the burden of proof is therefore on the state. And now Justice Toal is going to weigh in on this.
Your Honor,
after Creighton Waters.
And I'm going to walk through some of the cases in South Carolina that address this issue. But as Your Honor is aware, of course, when we deal with these issues, we have two types. We have internal misconduct, and our courts have been reluctant. Rule 606 says this as well, to delve into that unless there are concerns of fundamental fairness like racism and things like that. And then there's external allegations of external influence and that sort of thing. And that's what we're dealing with here today. And to quote State v. Grovenstein, which is a 1999 case of the State Supreme Court, it cites Aldred and Kelly and says, "We have consistently held the defendant must prove prejudice in these sorts of claims." And if we walk through all of the case law, our court has been very careful, and as much said so in Aldred, which was an internal case, to sync the analysis and the standards between those two, and have consistently held that the defendant has to show prejudice. It's their burden to do so. In Blake in 1992, the court held don't presume prejudice, and the test, of course, was whether or not the verdict was solely the product of honest deliberation or whether it was the product of outside influence. We go over to State v. Kelly. Of course, Your Honor concurred with Chief Justice Finney's dissent in that case, but in that case there was a pamphlet in the grand jury room. Clearly an external influence was alleged there. And ultimately in that case, the court held that the defendant failed to show prejudice from that particular external influence. In State v. Grovenstein, in this instance it was clearly external. There was an alternate who was present in the jury room and even took a preliminary vote with the jurors. So clearly an external influence, far more than is even alleged in this case. That juror was removed, curative instruction was given, but ultimately the court was very clear that we have consistently held the defendant must prove prejudice. Again, the burden being on the defendant. In Bryant, this was a capital case.
Must prove prejudice. That's the key.
And in that instance, there was a police investigation, background investigation into death-qualified jurors in a capital case. Clearly external. The trial court conducted an inquiry with questions submitted by the parties as well, and ultimately noted that it was the defendant's burden to prove actual bias on the part of the jury. In State v. Pittman, another case that I argued before, Your Honor, in that particular case, there was a juror who had a conversation with his wife and with the bartender.
And then again, you know, honestly, as you say, honestly, who else could be the killer but Alex Murdaugh? And that, I think, is the most interesting thing is in this case, there still has yet to be someone who has come from the defense and said, this is an alternate, this is a lead that was not pursued by the prosecution or by law enforcement. This is our theory of what happened. No one has come forward with that, which I think is, despite all of this legal maneuvering, it's interesting that no one has ever they've never offered up an alternative, even in the trial. As far as I know, unless you guys will tell me in the comments below, of course, as you often do. You can correct me if I'm wrong, but as far as I know, there was no other alternative suspect or anything offered by the defense. Still does not matter, though. If he did not get a fair trial, it does not matter. The thing is that, you know, again, this is a horrible human being who is admitted to doing terrible things, who has been convicted of the murder of his wife and his son. Horrific, horrific, horrific stuff. Yeah, it is. Thank you so much for the super sticker, Wishful Makeuping. I really appreciate it. Thank you, Gen X Granny. Yeah, I would agree, David, that he wouldn't have 3 lawyers there. Let's let this play, though.
Again, the court held that the defendant failed to meet the burden of prejudice because the wife's comment was the defendant was not guilty, and the comment to the bartender took place after deliberations had begun. And then, of course, in Green in 2020, Your Honor just commented on that, and the court clearly held that the rumor presumption of prejudice doesn't apply here. And then, of course, went on to note that the defendant bears the burden of proving prejudice. And Cameron is a case that they rely on a lot. And I would say this about Cameron, that Cameron, of course, goes on to say that the mere fact of any official communication does not necessarily mean that the jury was prejudiced, and went on again to do a prejudice analysis and a harmless error analysis. Covington is the Court of Appeals case from 2000. In this particular case, there were jurors who supposedly knew the defendant and knew some external information about whether or not he had had previous difficulties with his wife and that sort of thing. Clearly external information. And again, the court held that the defendant failed to show prejudice. So the case law in South Carolina, both from our state Supreme Court as well as our state court of appeals, is clear, it's in sync, it's uniform, that is the defendant's burden to show prejudice. And that's, of course, only after there's a determination that any sort of extraneous influence occurred. And that would be the state's position, that it is the defendant's burden. And again, we can address at the appropriate time what the state's position is as to the order in which the evidentiary hearing should go.
Thank you, sir. Mr. Griffin, can you reply?
Yes, Your Honor. There is a tremendous difference in the law as to how the court analyzes juror misconduct, as in Kelly, where the juror reaches out to her pastor, gets a pamphlet, brings it into the jury room, and that was found during the course of the trial. The trial judge removed juror O, who had gotten a pamphlet, voir dire every juror to ask what effect that had and if they could put that out of their mind and then deliver it.
Interesting about Becky Hill.
It was juror misconduct. All the other cases that he cited and the state relies upon are juror misconduct cases.
Oh, that's interesting.
Not unauthorized third-party communication that goes to the heart of the Sixth Amendment, right by a defendant to confront his accuser, to cross-examine witnesses who present evidence, when a third party makes an improper contact with the deliberating jury before they deliberate, that falls at the heart of the Sixth Amendment, which is a different animal altogether than where a juror engages in misconduct. And that's where you get to Cameron. That's where you get to Green, which Green says it was a procedural communication. Not
The jurors already gave testimony that anything that they were
Your Honor, dissenting.
that anything that they were not influenced. In other words, he had written on his face, "I did
Jurors
it."
were interviewed, especially we could tell by the
Mike Skidmore, but I watched the timeline of that,
It was a death penalty
and
case.
he only could have driven within a 20-mile or so radius of his dad's house in the timeline. Just weird posing of Maggie's pajamas stood out because they had to have been Alex, then driving to see his mother. Yeah, so I don't know a lot about the trial because I didn't watch until the last day. I was late to the party on the Alex Murdaugh situation.
Questioning the jurors' relatives and friends and trying to get their belief as to whether they believe in the death penalty. Apparently, some of that kind of leaked back to one juror, or maybe, but there was no record saying the jurors were prejudiced by that. But the court said that behavior cannot stand, and we find prejudice based on the conduct, not on the juror's testimony. And they didn't use the word presumption, but they found prejudice. And I don't want to get caught up in this issue of do we have to establish prejudice? I think prejudice is established.
Yes, Kim Weems. He will still be in prison. He will still be in prison for at least 27 years, even if this verdict or this case gets thrown out or he gets a retrial and he's somehow found not guilty. He's still in prison, and there's still other pending charges against him. So he's screwed either way, but which makes this all very interesting.
Merits of the case, the law is crystal clear that there is a presumption of prejudice, and the state has the burden of proving it's harmless beyond a doubt.
Thank you, sir.
Thank you.
That's another weird, interesting parallel. This blue tarp. So in my father's case, my mother was found in a blue tarp, which is kind of weird. A blue tarp that he purchased with me months before he murdered my mother. So that's interesting. There's a lot of parallels in his case and my own. And my father's case. Very interesting. Guns are probably buried deep in the swamp mud. Some rando. Oh, what a tangle web we weave. Absolutely.
You know, I'm not going to go back and forth a million times, but if you want.
Yes, Debbie Richmond.
Short comment and additional.
Very short, Your Honor. He said that these were not external influence cases, and every one of them that I listed was, Your Honor. Blake was a
Oh, it's okay, Lynn Clow.
Kelly was a pamphlet. Again, it was an external piece of information coming in. Grovenstein, it was an alternate. Again, that's an external influence. Bryant was a police investigation. Pittman was a bartender and a wife's comment. Green was a bailiff. And
now she's going to weigh in.
Evidence that was not admitted at trial that the jurors were aware of. So clearly all of those were external influence cases, Your Honor.
All right.
Now she's going to weigh in on all of this because they want to call the alternate jurors too. And she's going to put the kibosh on that.
I do not regard State versus Cameron as the guidance that needs
Thank you,
to be
Debbie Richmond.
used by me in making a determination about this case. It's a Court of Appeals case. Since that case in 1993, there have been several cases, including Green, Oliver, and others, that very specifically talk about this issue of what the burden is.
That's right. Chad Daybell's attorney's left.
On the basis for after discovered evidence that involves tampering or alleged tampering with the jury. All those cases say that prejudice must be proved, not presumed. And it may very well be that that is what's going to be shown. But for purposes of what the defendant must show as the case goes forward to an evidentiary hearing,
This is the key right here.
presumption simply by the contact, which we don't have any sworn evidence about except in the area of one juror at this time. A presumption is not the way to examine this issue, but rather specific evidence about what was said, when it was said, and how it was perceived by the juror. Is what I
How
believe
it was
is
perceived by the
required,
juror.
By State versus Green and other cases. And therefore, that is the approach I will take.
And that is the
All right,
approach
next.
she will take, which is it needs to show prejudice. It needs to show prejudice. That's what she's saying because they are trying. Sorry, text message just came in. They are trying to say that they don't have to prove that there was any prejudice. And she's saying no, putting the kibosh on this straight away before they even get into these hearings. She's laying all the ground rules as the judge should. She is not suffering fools. And yes, it is stressing him out. I would agree 100%.
Area of inquiry is the procedural argument of the state that this matter was untimely made. Mr. Waters?
Yes, ma'am, Your Honor. And again, we have raised the issue, as I talked about earlier, that we believe that there is at least an inquiry as to a procedural bar, that if the defense was aware of these allegations during the 10 days, then it is not after discovered evidence and the motion is untimely. And additionally, we also, as I previously expressed, have raised the issue that the affidavits on their face are insufficient to put in play an evidentiary hearing, and there are multiple cases that have in the state that have held, I think Yarborough is one of those that have held that where that showing was not made, that the trial court properly denied an evidentiary hearing. So we would just preserve those issues, understanding the court's plan of procedure that you previously expressed.
There you go.
All right. Mr. Griffin or Mr. Harpootlian, let me say that I will say to the defense, to the state, I believe that issue needs further exploration, so I am not prepared to rule that this matter is untimely in the least. We're going to have a hearing on this matter, at which time this issue will be further explored. So the state has preserved its position but you need not argue about that matter at this time.
Thank you, Your Honor.
And now the matter that to me is the heart and soul of what we're doing today is...
This is where she's going to weigh in.
The exhibits and the procedure needed with respect to the witnesses. And the witnesses, at least, are the jurors and the clerk of court, Ms. Hill. What I'd like each side to explore with me is how those witnesses should be presented, who should present them, and how they should be questioned, and whether there are any brackets or limitations that should be imposed on what these witnesses are asked. And I will begin with the jurors, which is really the heart and soul of the matter. Other witnesses are very secondary to the first issue, which is the jurors themselves. Mr. Harpootlian, you are the moving party, and you may proceed.
Your Honor, we agree all 12 jurors should testify. I think both sides agree, Your Honor, it's a question of jurors. The only question is, not only question, but the first question would be, as Your Honor questions these jurors.
Yes, and I think that's why Buster Murdaugh is not here. Is not because of his father, but because I think he's over this, and I think he's trying to extricate himself from as much of this as possible, because there's also a lot of danger too. And we're going to get into that a little bit later, because she's going to weigh in on these jurors and what is allowed in evidence, but we're going to listen to this a little bit more, and then we're going to fast forward, because they're going to take a break soon.
Would you, in all the cases the judge questions the jurors, would you want suggestions from us as to what additional questions after they respond to your questions, that raise additional questions? That's number one. Number two, each one of these jurors, except of the original 12, I think all have been interviewed. Maybe 2 have not been interviewed by SWED and given statements, recorded statements.
Hi, Sherry Falls. And Sherry Falls, welcome to the Patreon.
Memorandum of interview. We have reviewed
New
all
Patreon
these,
member, Sherry
videos,
Falls.
And the MOIs, and I can tell the court that the MOIs aren't consistent in many instances with what was said on the video, to the extent that information was left out. Now, if Your Honor is going to be very restrictive and ask, did the court communicate something to you, and did it affect your decision? I guess that's what we're hearing, Your Honor, when you're following State versus Green. If you're going to say that, ask those questions. There's some of these jurors who indicated they heard the court say what the juror that gave the affidavit for us say, and I think they're going to say it didn't affect them, which is fine. If it affected that one juror, we believe that's enough. And that juror has obviously given an affidavit to us. The alternate, which was excused, and we keep calling her the egg lady, but she was also excused, the alternate because she wasn't needed, the egg lady because the judge found that she had contact with people.
I think Alex Murdaugh is on a dating website, actually.
They further indicated that the court said what we say she said, and we believe they should be examined. We'll be happy to do that, or the court can do that. So there are witnesses, and then we have the court herself. I talked to her lawyer this morning, who indicated she has not made a decision as to whether or not she would assert any constitutional right not to testify, and obviously that would be on a question-by-question basis. Maybe, I don't know, we're not ready to argue what the standard is on the Fifth Amendment this morning. But if she does testify, there are literally thousands of emails that were furnished last week by
Oh, yes, Lynn Clow.
Colleton County.
Oh, yes, Lynn.
Some information furnished by SWED this morning and the Attorney General, which might be utilized. I can't say right now what it would or wouldn't, depending on her answer, to impeach, to contradict, and so I can't tell you what exhibits there would be or what we would do because I don't know what our answers are going to be. We believe we should be able to examine her as a hostile witness. We should be able to call her as a witness because the burden is on us, as Your Honor.
Now, hostile witness just means that they're not a witness for whoever is calling them. So a hostile witness is so they're a witness for the prosecution. So it's a hostile witness. It's not their witness. Is essentially what that means. Not that they're a hostile person, but this is interesting to me. And basically, Judge Toal shuts this down and says, "I'm not going to let you just have at Becky Hill, and you're not going to put her on trial here." She shuts a lot of this what Dick Harpootlian wants to do down, which is very interesting as well.
Now,
and he sort of kind of backtracks a little bit.
This. Even if Your Honor determines that a piece of evidence or a question is not admissible for your consideration for purposes of the appellate record, we believe we ought to be able to make a proffer. So it may be that Your Honor allows us to go forward, and then in your decision decide it's not relevant, in your decision decide you didn't consider it, or whatever. But stop and go is going to elongate.
Well, there are a lot of people that like that admire convicts.
You can decide not what a jury's going to hear, but what you.
Hey, Gypsy Rose got married while she was in prison.
We think that the examination of the court should be wide open, and we think that the exhibits we would use to impeach her, we would attempt to keep it relevant to the specific issues in this case. I mean, her son has been indicted, for instance, her son's been indicted for wiretapping. There seems to be some inference, at least what we read in the paper, we don't have any specific knowledge, that she was aware of that. And that
I'm sure his estate could profit from his story.
About her. That's not relevant. We're not going to ask her about it. Now, we're continuing to examine whether or not there
Susan
is some
Smith,
connection
interesting.
there, and we're investigating that. But at this point, I would tell you that's not where we're going. Where we are going, by way of example.
I don't know if he still has male and girlfriends, but he definitely did. Yes,
Furnished an
many.
email that
Very weird. I met one of them.
February
Very weird.
24th from somebody, which was a photo, a screenshot of a looks like a posting on some sort of Facebook page.
Now he's talking about the egg juror.
The ex-husband of a juror, not the egg lady, alleges that his ex-wife has been talking about the case, and she is going to vote guilty because she hates men. Now, we know she got it. We know she got it on February 24th. Yet on the morning of February 27th, she tells in the chambers, a hearing we were all present at, that she had seen a Facebook page posting by Egg Lady's ex-husband alleging that she was talking about the case, and she didn't think he was guilty. That Facebook page had never been produced, and then she produced a Facebook posting, she said, by the Egg Lady's husband. Turns out to be a guy I interviewed in Georgia, apologizing for what he had posted on Friday night, which concerned his wife's aunt meddling in their marriage.
So he wants to offer a proffer
for cross-examination. Your Honor may disagree with me.
He wants to offer these statements as proffer, and it's interesting because and she shuts all of this. She shuts all of this down as it keeps going in, because they are trying to present this. She hated men, all this conversations that had happened as proffer, presenting it in evidence into court, into the record, to show that, because they don't have to put the witness on the witness stand. They can just be like, okay, this is what was said, and it's entered, whether it comes from a deposition or whether it comes from a statement or whether it comes from an interview from SLED, and they can offer it to the court. And she shuts all this down, saying it does not matter because I'm not going to accept that, which is what we're going to get into.
to put those items into evidence for the appellate record at the time. The last thing I would say is this. In terms of Your Honor questioning the jurors, we need instructions from you as to whether you want, if you finish with the juror, do you want us to submit questions to you? Do you want, I doubt you're going to let us question them. How is that process going to work? And will that be done someplace?
That's correct.
Will it be done in this courtroom?
I know. Soon. We'll do it soon.
And
yes, you're correct, Shago
Outside
Guitars.
of this courtroom, will there be a way for the public to hear what they have to say? Thank you for your indulgence.
So I'm going to fast forward here.
And the incursion into deliberations, at some point, we don't need to know that today, but at some point prior to you questioning the jurors, we'd like you to enunciate what your position is on that.
You're going to have to outline that a little bit more for me. What part of 606B are you discussing?
Well, it says,
Oh, yes, the 606.
my glasses. Oh, An
606B.
inquiry into the validity of a verdict or indictment, a juror may not testify as to any matter or statement occurring during the course of the jury's deliberations or to the effect of anything upon that or any other juror's mind as or emotions as influence a juror to assent to or dissent from the verdict.
So from their pre-hearing brief, this is section E. It says Mr. Murdaugh will argue a preponderance of evidence that of the evidence shows Miss Hill made statements to at least one deliberating juror about the merits of the evidence presented at trial, which she was saying things like, don't believe him, watch his body language. That's what these statements are from. And this rule 606, so from the South Carolina SCRE, it says Miss Hill's denials should not be credited because her many acts of fraud and dishonesty, which will be explored in detail during cross-examination, demonstrate that she has a character for untruthfulness. CF Rule 606B, which is what she's referring to, and Toal shuts this down.
All right, so and what are you saying that in courts for this proceeding?
Well, I mean, for instance, if we prove to you that the court said, do not be fooled.
I would agree about the egg. I would agree about the eggs.
Watch Murdaugh's testimony, watch the body language inferring he was lying, he will be lying. One of the issues is if the juror who sat during the deliberations who said that the court said that, did she discuss that with any other jurors? Did she infect the jury? Does this allow you to do that?
Well, you certainly, if you go to 606B, it gives you some guidance about that. It says, upon inquiry into the validity of a verdict or indictment, a juror may not testify as to any matter or statement occurring during the course of the jury's deliberations or to the effect of anything upon that or any other juror's mind or emotions influencing the juror to assent or dissent from the verdict
The juror.
or concerning the juror's mental processes, except a juror may testify on the question whether extraneous, prejudicial information was improperly brought to the jury's attention or whether any outside influence
We love the Mennonites.
was improperly brought to
And their
bear
eggs.
upon any juror, nor may a juror's affidavit or evidence of any statement by the juror concerning a matter about which juror would be precluded.
Super Planner Girl, we gave you a shout out at the beginning of the live. Thank you for joining our YouTube members platform.
To give us the guidance we need about the parameters of the questions.
But if the juror that gave us the affidavit, would she be asked, did you discuss that during deliberations? Did she do that?
That apparently is very questionable under the terms of 606.
Yes, ma'am.
And I intend to abide by that. The way those questions have been asked in many cases I have.
Thank you so much, Super Planner
is
Girl.
to ask the juror whether that's still their verdict. If they asked about improper contacts, and they talk about improper contacts, then the way to pursue it beyond that for the judge is to ask about the impact on the verdict, not on the deliberations themselves. That may be a small slice of difference, but
And this is
I
it.
think it's very important to understand that no one, not myself or anyone else, is going to be asking the jurors about the specifics of their deliberation, and the rule is quite clear about that.
Okay. And is it clear that you will not be using the SLED interviews or MOIs to attempt to impeach?
I told you when that was brought to my attention in our Chamber's conference this morning, I haven't made my mind up about that. I don't know what's in those summaries or anything else, and we're going to have to discuss that. But again, I'm the one doing the questioning at this point, Mr. Harper.
Yes, yes.
And I'm trying to perceive what you all are asking, and I'm going to go to the state now and see what their reaction is to what you said.
Thank you, Your Honor.
So she just put the hammer down. She's basically like, I don't, and when he comes back to her and says, are you going to look at the videos of the SLED interviews with these jurors, and the sworn affidavits, et cetera, she's basically like, well, I'm going to do whatever I'm going to look at whatever I want. I haven't made a decision on that yet. So they're trying to really pin her because, again, they obviously want to get a retrial, of course, and they want to play up this whole removal of the egg juror thing. And she's saying none of that matters. And again, all of this, the only thing that matters is, did this affect the deliberation of the verdict? That's it. Did this sway the jury to vote a different way on the juror, the particular juror, to use their term? Did this sway the jurors to make a different, to come to a different conclusion in terms of whether they were going to say that Alex Murdaugh was guilty or innocent? And did it sway their decision? What we're going to get into later is what she's going to rule, and I've got to get to it here pretty quickly. But I can't imagine being known as the egg lady in court record. So weird. Very true. Yes, the judge is a no nonsense type lady. The thing is that the thing is that she's going to get into the main thing, which is, are they going to use, or are they going to let the witnesses come in and speak in open court, which, spoiler alert, they are. She wants them to come in, which proposes a really big conundrum. But let me keep this playing here.
Waters?
Thank you, Your Honor. May it please the court. Your Honor, again, we would concur with what Your Honor just said about Rule 606 and, of course, all the cases that we've talked about, and the need to show prejudice. And obviously, when you're talking about external influence, that prejudice, which will be an appropriate subject of inquiry to the jurors, is whether or not there was an impact on the verdict. And we, of course, have suggested to Your Honor, not only based on the cases, that should be judicially conducted in a manner that protects the privacy of those jurors and it protects the privacy of their identities. These jurors, were drafted into service, and this inquiry, of course, has to happen, but it needs to be conducted in a manner that respects their privacy and should be, of course, judicially conducted. We have suggested those two questions. If we look at the Bryant case specifically talked about the fact that depending on how the examination goes, there could be questions suggested by the parties. And obviously, I think we would need to cross that bridge if and when that bridge needs to be crossed. And that starts with the court's inquiry to those jurors, and only if something arises that needs further inquiry could that be addressed at that point. And that could be even a discussion from counsel with the court as to what additional questions.
I would agree, Jay.
When the state first became aware of these allegations, the first thing that we did was have SLED do an independent investigation, and the goal was, good, bad, or ugly, to get to the bottom of what, if anything, happened. And the result of that is why we're still here today. And that is that in speaking with the jurors that spoke to us, that the balance of the evidence, as well as in talking to the clerk staff, was that there was no impact on any verdict. There was nothing unprofessional or untoward that happened that had any effect on the verdict. And so when we did that inquiry, and that is what the jurors said, that is why we're here today, and that's what this hearing is going to address. The only juror that we have is the one who filed the affidavit. That's 630, and even she, or that person, only said that she, eventually voted guilty because she felt pressured by the other jurors. Did not even mention any external impact. And so unless she's going to change her story, that is what was in her affidavit. So the balance of the evidence is the reason why we're here today and why this hearing needs to take place. Your Honor, as far as inquiry to those jurors, again, there could be a need that the parties would suggest questions, and it could be, depending on how things go, that the affidavits or maybe even the recordings, all of which have been provided to the defense, the full recordings of those interviews of any potential witness in this case have been provided to the defense. It could be that issues could arise from either the state or the defense as to impeachment, and we can address those issues as they arise under the appropriate rules, 608, 613, and the like, dealing with not only prior inconsistent statements, but other evidence that would be properly impeachable. Ultimately, I do need to address one thing as it deals with all of this, and that is the defense's contention that somehow the clerk is a party opponent in this particular case, and we believe that that is incorrect. Obviously, there is a hearsay exception or a non-hearsay determination in the evidentiary rules, I believe in 801, that excludes statements of a party opponent. But just because the clerk is an elected official and of the state, that does not make them a party opponent in the way that term is defined. A party opponent is an active litigant before the case, and that is, I think, different. So we would certainly say that the hearsay rules would still be in effect as it relates to Ms. Hill and any testimony that she may provide. I know there's been some discussion about the order in which the witnesses may be called and whether or not Ms. Hill would be a hostile witness. And obviously that's under Rule 611 and I believe C, which will allow leading questions, if a person is hostile. I think, again, at this point, I don't know that any showing necessarily has been made, but I understand the defense may raise that point, and we may have some arguments at that time. But I don't know that there's been such an identification between Ms. Hill and the state that would allow, A, her to be identified as a party. I think that's far out of bounds, but also that she would be applicable to allow defense leading questions under 611C. Your Honor, in looking at the type of examination that would need to happen here, and again, the issue also arose of the Fifth Amendment. And I know that the defense would like to brief that issue, and we're happy to respond. We don't know exactly how that might arise in the course of any examination. We need to cross that bridge again when we get there. We would say, though, that the Fifth Amendment is question specific, and so again, it may be something that this court has to rule.
No, the defense is not getting their way.
Question by question.
This does not look good.
Objection by the party. So it's kind of hard to say that exactly what the blanket position would be until we actually get to that determination. Ultimately, the defense referred to some information provided this morning. Actually, both sides exchanged last night their communications with the clerk during the course of the trial. So both sides did that last night. And there were a lot of communications with the defense as well. And so, again, I just want to point that out that there's any sort of allegation or insinuation that the state's not providing information. We've been very diligent about providing any and all information to the defense. And if any additional information arises, we will continue to do so. But both sides exchanged that last night. And of course, there's been some reference in their filings as to emails that were forwarded from the clerk to me and to my paralegal, and they've actually even listed me on the witness list. And Your Honor, as we have had a chance to peruse the defense communications with the clerk, there was just as much communication and offers of help. It was just a uniform across the board courteousness that's reflected from those. So we think that that's a non-issue, and we think that should not be something that arises during the course of this evidentiary hearing, at least as it would require communication from or testimony from attorneys. Your Honor, ultimately, as we look at...
Yes, and I would agree. Yes, it looks like Dick Harpootlian has a sunburn. Yeah, he looks like he's about ready to explode. They all look like they're about ready to explode. And, and Creighton Waters looks like he's just so over this. He just wants to shut all this down. But I think that this is just, I don't know. A lot of this doesn't sit well with me.
The
Not going to lie.
that will need to be conducted, as the state has made clear, it starts with the jurors. And only if something arises in that inquiry, further inquiry to those jurors may be necessary. And that could be in discussion with the parties, as I've stated before. And then, I know Your Honor has indicated the clerk should testify, and we certainly understand that. The clerk filed an affidavit denying any of these allegations. And so, again, as we address the clerk's testimony, the state would have objection to some of the information I believe the defense would propose to examine her on. We believe that an inquiry should be limited to what is appropriate and relevant impeachment, but not should be just a far-ranging fishing expedition or full inquiry into a lot of subjects that have come up since the trial that we believe are not relevant to any point.
So now let's just go a little bit further here to Mr. Herb Williams' response.
Take the positions that I've outlined here today.
You reply.
Please, Court, Your Honor.
Oh, I'm sure the red face is from his alcohol abuse, for sure. Rosacea.
404, I find it somewhat ironic. The state is quoting Rule 404, Your Honor. One of the exceptions to 404, I know this will be surprising to Mr. Waters, is motive, as if he'd never heard that before. He told me this morning one of the assistants that worked for Ms. Hill during this trial was told by Ms. Hill during the trial that a guilty verdict would be good for sales of the book. Motive, selling books. So we believe we should be able to get into that. We should be able to ask Ms. Hill about it. If she denies it, to call that witness, that assistant, and have her testify that she was told that. I mean, why would a clerk do what we allege she did? We think is important for Your Honor in terms of
I agree.
credibility and context. That's number one. Number two,
I agree.
Your Honor, I think we've all agreed. You're going to ask the questions, whether we agree or not. And we do agree with that. The question's going to become,
Golf course
as
with the
we
full
go through
bar
that
are in the
process,
cooler.
how, if a juror says X and they've said in their interview Y, or if they've said to us Y, or didn't include it in their original affidavit, and you don't ask that question initially, how are you going to handle, or do you care, how we suggest to you a further question? Because as Your Honor's seen this morning, the back and forth can go on for a while, and we certainly don't want that to go on with a juror. So we're going to need some guidance on that. I'm not expecting that guidance this morning. But the last thing is,
Oh, he's
as
pandering
the-
to her, which is
as
kind of
these jurors
funny.
are examined, I need to understand a little bit about the logistics. Are we going to do it in this courtroom? Are we going to do it in another courtroom? Is the public going to be able to hear the responses? Will there be an audio feed if we do it somewhere else? Are you going to have cameras turned? You can do it in this courtroom, have cameras turned off?
So now she's going to weigh in
refer to jurors
on the cameras and on the courtroom and
even
what's
though
going to be
3
allowed.
jurors went on the Today Show, another one went on ABC. They were all in the courtroom when the judge had them brought in. They were in the courtroom, all except one of them, for the verdict. Cameras were there then. Again, I'm sensitive to their anonymity, but I don't know that any of them have any real anonymity anymore. Saying that, I think it's important not only for Your Honor to hear their answers, but for the public to hear their answers. Thanks.
Now, here's what I have to say about this. And this is something I feel really strongly about. So the judge is gonna weigh. I'm gonna spoil this for you because I gotta get going soon. But we got about another 20 minutes. But one of the things that I find as someone who has testified in court, who has been to court, who's been in criminal court, is that it's very scary for people. And what this judge is going to weigh in on in a second is she's going to basically say that they are going to allow the courtroom, I believe it's Court TV that does the courtroom stuff. They're not going to allow them to film the jurors. We can play this, but they're not going to allow them to film the jurors. But the jurors, they're not going to use videotaped evidence. They're not going to use statements. They're going to have them come into the court, which is open to the public. Now, I believe, as someone who's been through this is very bad for the defense, because this is open court in South Carolina, and South Carolina likes to do things like this, apparently. This is obviously, you would hope that people who come into the courtroom are going to keep the anonymity of the people that are, because these jurors are labeled by numbers. They are not labeled by name. So there's many people who are represented by Bland and Richter, for example, 4 jurors who have anonymity. There are other jurors that are represented by Mr. McCullough, who are Murdaugh-friendly jurors, according to some people, who have anonymity. The thing is that if you go in and you would think that, of course, there's a sense of decorum that the public would have as they go in, but this is a small community with ties to everyone down there in the Low Country. When you go into the courtroom and you are giving your statement, you might not be on the court TV cameras, because she's not going to allow them to be filmed. And even Mr. Bland and Mr. Richter even suggest about altering their appearance, altering their voices, so when they're heard over the dialogue, nobody knows who they are. But everyone in that courtroom, you don't think these people are going to come out and talk? I mean, you hope they're not going to, but of course they are. And it's going to spread like wildfire in the small town community. And if you think that there's going to be some juror that's going to come on there and say, and it's going to be the linchpin in all of this, the straw that breaks the camel's back, and say, I changed my verdict because of what Becky Hill says, and this whole thing causes a retrial, I think their personal safety, the safety of their family, their privacy, it's gone. People are going to say this person testified this and went against it, and they're the reason why Alex Murdaugh is getting a new trial. And I would fear for my safety. And that, to me, is what goes against the defense. That plays the biggest part against the defense, because not only are they not allowed to have jurors come in, or jurors come in, who were alternates or who had been kicked off, like the egg juror, who might have evidence that they say proves that Becky proves beyond a reasonable doubt, or creates a burden of proof upon the prosecution that that the jury was tampered with, and that this did alter people's verdicts, right? But now you have people who are coming in with the massive duress of the fact that they could be the ones that would be called out for possibly being the ones who cause or are the reason for a retrial of Alex Murdaugh's murder conviction, and possibly being overturned. You don't think that they're going to face massive public excoriation and chastisement? Come on. Their lives are going to be, I would imagine, and that's going to put, an immense amount of duress on them. And I think personally, really, is a massive blow to the defense, because their anonymity is not being preserved, and they are going in front of the court so they can be. There's a lot of intimidation that could come down from the community at large. I wouldn't want to be the one who's like the whistleblower who says, no, this is what happened. I mean, yeah, we want to be virtuous and say that, oh yeah, this is going to be great and all this. But really the truth is that this could be a major problem for people, And that's what the judge is going to rule in. I'm going to let it play, but I want to weigh in on that, because I see that being a massive problem. I wish there was a way I could fast forward this easier. Come on.
Jurors first as witnesses. I will be doing the questioning of the jurors, and I will notify the parties pretty promptly what I intend to ask the jurors.
I guess I missed the part with the open court. Hold on here.
Not to refer to jurors by their names. even though 3 of these jurors went on the Today Show, another one went on ABC. They were all in the courtroom when the judge had them brought in. They were in the courtroom, all except one of them, for the verdict. Cameras were there then. Again, their answers. Thanks. Thank you.
All right, here we go. Sorry. Oh, I'm so sorry, Lynn, you have to shovel snow. That's terrible. Stay safe. Stay safe. Yeah, I think this puts people's lives in danger and livelihoods in danger.
Right. With respect to the jurors first as witnesses, I will be doing the questioning of the jurors, and I will notify the parties pretty promptly what I intend to ask the jurors. The ambit of what I will be asking them is informed by the question of whether improper contact was made with them and whether it affected their verdict. I understand that you, on the defense side, have views about what further should be asked the jurors on 2 levels. One, as a predicate to what you want to do with the clerk herself in examining her. And 2, as a means of further attacking the credibility of the clerk in her testimony. I have not seen any of the SLED material or memoranda concerning the state's summary of these interviews and so forth. I will be open to receiving that if it's done promptly, because we've got a hearing.
I agree. So, yes, we all know that social media, I mean, they just spoke about the Facebook post and calling out the egg juror and how it appears that Becky Hill, in what everything we've seen, weaponized that to get someone off the jury. And now you have where people will be allowed in the courtroom, jurors will be seen. And yes, they could be bullied on social media and online. It's crazy.
Every piece of conduct by the clerk alleged to have been improper on its own, indicative of her characteristics or personality or anything of that nature. This is a very focused inquiry that deals with this jury and what impact contact, if any, had on this jury. So I am very mindful of the limited nature of it. As I say, I'm not excluding submission in advance of information that would take the questions beyond the limited questions I've initially indicated. But I will be very hesitant about any of those questions as it involves propounding those questions to the jury. As it involves questions to Ms. Hill similarly, this is not a time to explore every mistake or incorrect statement or false statement that ever has been made by this witness. I am the judge of the credibility of this witness for purposes of this new trial motion. I don't think it's necessary, nor do I think it's proper, to explore each and every impropriety alleged to have been committed by the clerk. At the same time, what specifically should be asked is something that I will look at as I look at the submissions that are made before the hearing takes place about what is requested to be allowed as topics for questioning of the clerk and what exhibits should be used. I can't imagine allowing thousands of emails to be made exhibits in this process. Either emails sent by her to attorneys in the case, to other court officials in the case, or to other individuals during the course of the trial of the case. I certainly will try to preserve the appellate posture of defense in this regard, but I will put certain limitations on just a wholesale exploration of every problematic piece of conduct, ethical dealings with the county, and so forth. This is a very focused inquiry about this jury.
Now I'm going to jump ahead.
Ability to render the verdict it rendered in an impartial manner.
And that's what it's about. Now I'm going to jump ahead to where Harpootlian asks her, this is after the break, so Alex Murdaugh goes back, blah, blah, blah. They take quite a bit of a break. The other lawyers are called up here, I believe, before this happens. Maybe not. Okay, so this is when, so Dick Harpootlian is asking for clarification of whether or not he's going to allow the alternate jurors to talk.
And then after that, we'll explore the attorneys for the jurors and the attorney for Clerk Hill, any other issues that still need to be developed. Mr. Harpootlian.
Please support, Your Honor. I'm trying to make sure I understand what you've just ruled. Are you ruling that we cannot call the alternate juror or the so-called egg lady to corroborate what was said to the sitting jurors, since they were all told this at the same time?
Yeah, the defense.
I'm not sure I understand your question, but I'm telling you that I want these jurors, these alternates, would be called apparently to testify as to what the clerk said.
Yes.
At the present time, I see no necessity for them to be called to say what the clerk said, because we're talking about what the clerk said to the remaining jurors, those who actually sat on the case. The corroboration is something I don't think I need at this time. I think I'm perfectly capable of evaluating what the jurors tell me, and I'll do that. I think I'm also perfectly capable of evaluating the credibility of Ms. Hill and the jurors, for that matter.
Well, Your Honor, for us to, and then you said you wouldn't allow a proffer of that except in writing. Now,
yes, I'm not going to have a courtroom proffer of any kind. If you want to proffer what would be offered by means of affidavits, copies of emails, anything else you want to, that's fine. But I am not going to have a courtroom proffer, no. I think the only reason for the proffer would be to preserve your right to appeal. I believe your right to appeal, my rulings will be perfect.
Now, just so you know, a proffer is a mechanism to offer or present evidence at trial for immediate acceptance or rejection by the judge. Just so you know, it can be statements, depositions. It's something that's offered into the court to be put into the record of the court. So statements from witnesses, etc. It's just a time-saving thing instead of calling someone to the witness stand.
Frankly, even if you didn't have a proffer, but even more so if you supply an in-writing proffer.
Well, I'm trying to determine whether an affidavit is sufficient for an appellate court, federal or state, when the state won't have an opportunity to examine that witness. But I mean, they've given, I mean, we can get more detailed affidavits, you know, these people are witnesses to
I would agree.
What the clerk said to the juror who deliberated. I don't understand how that can't be relevant to Your Honor's decision. I understand there's two steps. One, did she make the statement? And two,
He's playing Eggman with himself. That's
these
funny.
witnesses corroborate she made the statement.
Well, of course, that's what you say. So far, I haven't seen any of that. If that's what you say and you offer it to me in some form that I can evaluate it, I may revisit that decision. At the present time, but at the present time, I see nothing that prompts me to think I need to have people who did not sit on the case talk about what they think the clerk said to other people when I've got to direct people to whom it said that I will question.
Well, Your Honor, we did submit an affidavit, but I have no problem with going back.
You submitted one alternate affidavit,
right,
and one affidavit of a dismissed alternate. I'm aware of that.
Right. So.
And that doesn't prompt me to change what I've just said to you.
All right, we can get you more specific. I understand what the questions are you have, and I would only put those folks up to deal with.
So the crux of the defense's motion for the retrial, like the main part of it, is that they're arguing that Becky Hill had motive and also actively participated in removing jurors who didn't agree with her verdict. Like the egg lady juror, right? So that she manipulated things like putting a social media post up to get this person removed that didn't align with what she saw as a verdict. That's the crux of their argument. And basically what the judge is saying is none of that is going to be allowed. None of these other affidavits from these other alternate jurors. It's only the people that actually sat on the jury. And they will be brought here in open court for everyone to see while they make their statements. That to me is just, I mean, look, she's a judge and these people will know way more than I do. I mean, I am not a lawyer. I am not law enforcement. I'm not a psychologist. I'm just a guy who's been through a lot of shit. But let me tell you, this to me just seems really just,
would be a good solution.
I mean, it's obviously it's obviously not good for the defense, right? But to me, this just seems, I mean, the fact that a clerk of court, and I'm going to wrap this up, the fact that a clerk of court is going to is able to write a book, able to seemingly abuse their power, and whether or not we like it, have some sort of influence over the jury, whether she had any sort of direct contact with alternating the jury's verdict or not. There is so much that is up in the air, and there's so much left to be explained. It just feels like to me that this situation, and I do not like Alex Murdaugh at all. And I know that a lot of people are very much want to see him fry and be in prison for the rest of his natural life, which he already is going to be anyways. He has other charges that are coming. I mean, the guy's screwed. But, again, the system has to work for the worst of us, so it works for the best of us. And to think that a clerk of court can come in and do all of these things, and then this somehow does not penalize or does not merit this could happen to anyone, is the point. This could happen to anyone. And that to me is the biggest problem, right? That to me is the biggest problem with all of this is that, we see that she wrote the book. We have people who've come forward. We've seen all the media publicity that someone could be involved in this way in our legal system. I don't know. To me, it doesn't. When you think about how our system in general, or our societal mechanisms that are in place, social media, things of that, how that affects people, how that affects our views, it affects politics. How these things are shaping our future. Just allowing people to have to come in and alter or do things that are just not kosher. They're just not kosher. That to me, it bothers me a lot. And I don't, I want to see everyone get a fair trial. I want to see everyone be able to, because again, if this happens to the worst of us, it could happen to the best of us. And I think that's it. But it doesn't matter what I think. It matters what you guys think. Let me know in the comments. You guys are just, you guys are letting me know right here. we will, I'll be keeping up on all of this. I am very much looking forward to seeing what happens on the 29th and, what will be brought to light. It seems like today was a massive blow for the defense, though. And I think leading up to all this, I think we can kind of see which way this judge is leaning, which is more than likely Alex Murdaugh will probably lose his bid for a new trial or a retrial, and they will have to go back to the appellate system and go to a higher court and redo their appeal and cite all these things. And this will be a never ending process like it is in the legal system. And, this is all just it's wacky to me, but, I think it's wacky to everyone. But oy vey. Again, this might be proven it was a fair trial, inappropriate what Becky Hiller may or not have done. But as long as it didn't affect the verdict. Yes, and absolutely. And again, but we want to see someone get a fair trial if that's the case. But it's interesting. We'll see how it all plays out. But please let me know in the comments below. And do me a favor, guys, if you can, please subscribe if you're enjoying my videos. Please share with your friends, family, everybody who's interested in this. I have a whole Murdaugh playlist. Check it out. I will be live tomorrow on Surviving the Survivor at 5 p.m. Eastern time, and I will probably be streaming that to my channel as well. In fact, I will be. So you can check it out there. You can check it out on my channel, and I'll probably do a live afterwards at some point. I don't know how long we're going to go. But we'll discuss all these things. And again, thank you all so much. Mover Nation, thank you so much. I want to say a big shout out to all my channel members, all my channel subscribers, and all my Patreon patrons. Thank you all so much for your support. I greatly appreciate it. But if you could, please click that like button. It helps with the algorithm. I appreciate all of you showing up and being here and participating in the comments. This is a great little community we have done. And wherever you may be and however you may be watching or listening, thank you so much for making me a part of your day. Mover Nation, we get through another one, and I greatly appreciate all of you. Have a wonderful night, and I'll see you on the next one.
This podcast is made possible by support from listeners just like you. For exclusive content around this podcast, please consider supporting me via Patreon by going to collierlandry.com/support. Please subscribe via Apple Podcasts or wherever you get your podcasts from, and please leave us a 5-star review. If you want to see video episodes of this podcast, please check out my YouTube channel at youtube.com/collierlandry. You can find links to additional resources in the show notes of today's episode. This podcast is a production of Don't Touch My Radio. Copyright Collier Landry.